Florida guardianship litigation in light of Florida revocable trusts or living trusts. My name is John P.L.L.C. I'm a Florida probate attorney with the P.L.L.C. law firm in downtown West Palm Beach. I'm going to be speaking to you about a probate litigation topic that includes guardianship as well as trusts. Everybody is using revocable trusts or living trusts as part of their Florida estate plan to not only manage their wealth and distribute inheritances when they pass away, but also to manage their funds and protect their assets during their life, such as when they're incapacitated. And that's what happened recently in a case that was out of the 2nd District Court of Appeal in Florida. Florida's 2nd DCA issued an opinion on February 26, 2016, in re Guardianship of Ronald J. Mount, M-O-U-N-T. The case number was 2D15, 2nd District, 2015-2052. And the issue before the appellate court was regarding a guardianship appeal, and it had to do with the ward's revocable trust. You can avoid a guardianship under certain circumstances if there are lesser restrictive alternatives to a guardianship which properly address the needs of the ward. Many times people can avoid a guardianship in Florida by having a durable power of attorney, having a revocable trust with a trustee, and having somebody who can make healthcare decisions for you. In this particular proceeding, there was a non-final order that was entered in 2015 in a non-adversarial Florida guardianship proceeding. Florida guardianship litigation is actually expanding, or it seems to be expanding. Many times adult children of somebody who may have diminished capacity are filing guardianship petitions, and many times the family is at odds on who should make decisions for a ward or an alleged incapacitated person, or whether that person needs a guardianship at all. And so we see, at least in our Florida probate litigation practice, guardianship petitions being filed with more frequency. So in this particular guardianship proceeding in Florida, the ward had a revocable trust, and he had trustees, and there was an order from the guardianship compelling the trustees to do something, to return some funds. In Florida, you get a court-appointed attorney right away when a guardianship petition is filed. The reason for that is obvious. When we speak about guardianship proceedings or contested guardianships or filing for a petition of guardianship, this is very serious stuff. We're dealing with someone's rights, someone's civil rights, civil liberties, and human rights. And so the courts in Florida take that very seriously. So one of the first steps that they do is a probate court judge will appoint an attorney who will look out for the alleged incapacitated person to protect them and only them. So there was an order compelling the trustees to return some funds to the guardianship account, and that was granted. It was reversed on appeal. The 2nd DCA said, in the absence of an action properly commenced by the guardianship against the co-trustees, the ward's beneficial interest in the trust does not afford the guardianship court the authority to override decisions of the co-trustees in the management of the trust. And the court cited Cohen v. Friedland, C-O-H-E-N v. Friedland, F-R-I-E-D-L-A-N-D, 450 Southern 2nd, 905. That's a 1984 3rd District Court of Appeal case out of Florida. In the absence of proof that the trustee has failed to perform or has performed arbitrarily, a court is without authority to remove trust assets from control of the trustee to be administered by the court or other guardian. Now, it was interesting why the trustee was before the court. One would think if the trustee is before the guardianship court, they're submitting the personal jurisdiction, and they'll be subject to the guardianship court's orders. Trustees of revocable trusts may be interested persons in a Florida guardianship proceeding and may be a proper party to participate in the guardianship administration. What the court seems to be saying is a guardianship court is not going to second guess a trustee. A guardianship court is there to protect and look out for the ward. What it sounds like the 2nd District Court of Appeal is doing is inviting the trustees, inviting the court-appointed counsel for the ward to take a different procedural path. right? And what they're probably saying is you need to initiate a lawsuit by filing a civil action against the co-trustees, and a judge in that proceeding will determine whether the trustees acted properly or arbitrarily. And if they did act arbitrarily, or if they abused their discretion, the court can provide the court-appointed counsel for the ward with relief, such as return the funds. But the guardianship court here seemed to be saying, we're not going to do that. We're not going to make that decision. Go file a trust action. Find a trust lawyer or somebody who handles trust litigation in Florida. File a separate civil action. Let that court go and decide whether the trustees acted properly or not, and whether the trustees should return funds to the guardianship account. So you can have a trust action that's ongoing. Most circuits in Florida will require a notice of the companion case to be filed. In Palm Beach County probate litigation, there's a local administrative rule that says if there's a companion case, you should file a notice of that. And generally speaking, the higher case number is transferred down to the lower case number, and the matters are consolidated. This may or may not make sense. I know some circuit court judges in Palm Beach feel that if you don't file that motion to transfer or motion to consolidate soon enough, that issue is waived, even though the administrative rule is mandatory. It says shall. So the takeaway from all of this, if you're involved in a guardianship matter in Florida and you want the court to exercise jurisdiction over the trustee, is consider whether the trustee is appearing voluntarily, whether they've consented to jurisdiction, and whether the court has the authority or the subject matter jurisdiction to compel or command the trustee to do something, or whether you need to go file a separate civil action. It sounds like in this particular case, the trustee did not agree that the court had jurisdiction over them to enter orders compelling the trustee to do something or refrain from doing something. So this is an example of a Florida probate litigation topic that's cutting edge. Today's April 21st, 2015. This was issued just a couple months ago. That combines guardianship litigation in Florida with also trust matters in Florida, or trust issues in Florida, and trust litigation. My name is John P.L.L.C. The P.L.L.C. Law Firm in West Palm Beach handles guardianship litigation as well as trust litigation and probate litigation in Florida. Thank you.